Intermittent watercourses shall be delineated by defined permanent channel and bank in the occurrence of 2 or more of the following characteristics: evidence of scour, presence of standing of flowing water for duration longer than a particular storm incident, and the presence of hydrophytic vegetation. Now, the next big definition that you run into, and I'm sure it's in your regulations, is what is a regulated activity? All right, this is an important definition. It's an important thing to be aware of. So 22A-38 defines a regulated activity as any operation within or use of a wetland or watercourse involving removal or deposition of material or any obstruction, construction, alteration, or pollution of such wetlands or watercourses, subject to certain exceptions, which we'll cover later. Some of these words, these are all kind of broadly defined. And thus a permit is required for any defined, quote, regulated activity. And that's where you guys come into play. So you're the Inland Wetlands and Watercourses Agency, and people come in front of you to get a permit for perhaps regulated activities. Now, there are other instances where local field conditions are going to prevail over your, if you have an inland wetlands watercourses map, then somebody goes out in the field and they flag it, it may be different than the official map. That's very common. And getting properties flagged is important because it can be very different than what your official map actually has. All right.
Matt, I'm gonna jump in again.
Go for it.
So I thank you for bringing that up, because there are issues with maps. There's scale. It can't show everything down to the tiniest little, spot. There's the date of the data that was used to form the map. So while maps are really good to guide, and especially for citizens that, just kind of want a general idea of what's going on, they're for general planning purposes. And so field conditions really dictate what is a poorly drained, very poorly drained alluvial or floodplain soil.
Okay. The next definition that comes up are upland review areas, or sometimes they're called buffer areas. I know DEEP prefers upland review. You'll hear both words used. It's okay. So this allows certain activities that occur outside of the wetlands and watercourses to be regulated, as long as there are reasonable grounds for concern that the activities in that area might pollute or affect an inland wetland or watercourse. Now, to be clear, that doesn't mean that a buffer area or an upland review area is like a wetland. So it doesn't, you're really focused on what are the impacts on the wetlands and watercourses, and it's not like a no-fly zone. It's something that you consider, it's something that you look at, and it's something that's used kind of administratively to kind of help people understand how close am I to this watercourse or wetland, and what should I be doing. This has been incorporated in the statutes. They are not prohibition zones. They are very helpful. Just about every commission uses buffer areas or upland review in order to better understand an application, and also to better understand what the impact might be to a wetland. And these are all things that you should have in your regulations, and I'm sure that you do. I didn't read your regulations beforehand because that would have ruined all my questions and stuff. So I wanted to keep it kind of exciting. And, these kinds of things that you have to focus on. Now, other issues that come up are regulation of flora and fauna outside of wetlands and watercourses. Now, this is always a point of interest sometimes for applicants, the agency, and perhaps people who are opponents to a particular application. But this all comes down to whether or not the wetland or watercourse itself is impacted by whatever might be disturbed for any species or plant. The case of River Sound Development upheld the denial of a wetlands permit application based in part on expert testimony that the proposed development could harm wood frogs outside the wetlands area, and that such harm could affect the wetlands and vernal pools itself. So you need testimony, you need expert testimony when you start talking about those kinds of issues of disturbing flora and fauna outside of a wetland area or watercourse.
So I'm going to jump in again. So this is a really confusing area, at least in my experience for, municipal and wetland commissions. And often it does need expertise. You have to dot your I's and cross your T's and link things to an adverse impact to the inland wetland or watercourse. And so this whole connection to what is the, the physical characteristics, there's a section of the law which should be repeated in your regulations. If you have an activity going on in the upland review area, upland, I'll just call it, the law is saying that you have to demonstrate that it's going to have an impact to the physical characteristics before you can kind of pull in the, what I'll say, the bugs and the bunnies and the plants and so forth. But that could be something like turbidity. That could be removing shading, and now something's warming up, or it's not a cold water, stream, for example. But it can be confusing, this section, and so just walk through it carefully.
Okay. Some regulations contain certain prohibited activities outside of a wetland, like septic systems within like 100 feet of a wetland. Those have been upheld, but normally flat out prohibitions aren't necessarily my favorite way to view wetlands. There are instances where planning and zoning commissions may consider certain wetlands issues if they're set forth in their regulations. But in the end, you don't have to worry about that because that's their regulations. You only have to worry about your regulations. Now I'm going to go through some exempt activities, and I'm sure Darcy's going to want to interrupt at some point on this one. I got a feeling. These can be issues that can get, they can get kind of excitable. One of them is grazing and farming, things like that. Certain residential lots. I mean, the farming exemption does not include the building of roads. It does include other farming uses that you might have. So in my lifetime, I've seen people try to make certain farming exemption claims, and they've been kind of dubious. They do it because they don't really want to go through wetlands. And so that can become an issue of itself. I don't know how often that happens before your commission, but certain commissions get it a fair amount. And that is just something to be aware of. You always have the ability to determine whether something's exempt. That's your power. So if someone says, I'm not coming before you, I'm exempt, you have the right to say, no, you got to come in. We got to know what you're doing. And that is a jurisdictional issue, and that has been upheld. So that's an important aspect of being a wetlands agency. Now, other things that are exempt is a boat anchorage or mooring, uses incidental to a residential property, the construction and operation by water companies, or by municipal water supply systems, concerning dams, reservoirs, and other facilities necessary for the storage and withdrawal of water, maintenance related to certain drainage pipes. In addition to the foregoing, the statute provides that the non-regulated uses are exempt, provided they do not disturb the natural and indigenous character of the wetland and watercourses by removal or deposition of material, alteration, or obstruction of water flow. There are certain instances where these are like lesser exemptions. So outdoor recreation, installation of a dry hydrant, they don't get the exact same exemption, but as long as you're not mucking things up, you're going to be okay. That is not an actual expert term or legal term. I was just kind of helping you get there.
So I am going to jump in again.
I knew you would. I knew you would.
I need like a flag, you know.
No, just say something. I hear you really clear. Don't worry.
So, you know, I've often been asked, and maybe you've been asked this question, why did the legislature create 2 exemption sections? There's one that's as of right, and there's one that's non-regulated. I don't know unless I, you know, dug into the history of it and the debate on the floor of the Senate and House. But sometimes I tell people that the things that are as of right tend to be more complicated operations and uses, like farming. Farming consists of a lot of activities, and some of those activities may be ruled as of right. Some might require a permit. So sometimes it's easy to take these different bits and parts and separate the sentences apart and create like bullet points so you have a better understanding of what these exemptions are. And if you'll notice, each exemption has slightly different kickouts, I call them. The kickouts are the things that require a permit no matter what. So like Attorney Willis said, if you're filling a wetland, even though you're farming, if you're filling a wetland, that one activity of filling the wetland requires the permit, but the rest of the farming operation might be ruled exempt. And the non-regulated uses, I often tell people, maybe the legislature separated those aside as non-regulated because on face value, for the most part, what you see is what you get. You're not going to make everybody who wants to swim or go fishing or kayaking to come before you for a permit. And those are often licensed by DEEP anyway. Not all the activities may be obvious. You still, you know, have a right to ask people to present information. But this section of the law is sometimes best read when you break out all the little parts into bullets. Thanks. I'll be quiet now.
Oh, you can always jump in. That is not an issue. The appellate court has upheld regulations that require a landowner, before conducting activities within a regulated area under a claim of exemption, to request determination by the Wetlands Agency as to whether the activities are exempt. So that's important for you to realize that you can have people before you that may want to say, well, we're actually exempt, but they have to describe what they're doing. I mean, I've had people come before inland wetlands agencies and they say, well, we're exempt because we're going to be farming. Oh, well, what is it you're doing? Like, you know, you're just planting a cornfield, or, you know, so you kind of get that out of people. And, you know, some people don't like coming before governmental agencies. And that's one area where you may see it shine the brightest, is with things like the farming exemption. Now, before I get on to the next part, which is basically your decision-making procedures, I'm going to talk about things that before somebody files a permit. So statutorily under 7-159B, you can have informal meetings. So people can come before you to have an informal discussion, perhaps about an activity, perhaps about some sort of project they might be having, and that's perfectly fine. That can't be used against you. The statute's pretty clear about that. So that's kind of a, you know, you might not necessarily have all your details, so you might necessarily totally know, but sometimes applicants would like to get maybe a direction. The best place to do that is in an informal application. You may get sometimes incomplete applications. You always have to remember the burden is on the applicant for everything. All right. So they have to file applications. They have to make an argument that they're exempt if that's the case. the burden isn't on you to figure out whether they need a permit until they've done the correct things before you. So if you get something like an incomplete application, then you can kick it to your next meeting. You have the time. That is a permissible thing to have happen. You don't want to get yourself boxed into a corner until you know you have all the information that you need. All right. Yep. I'm sorry.
There's a few hands raised. I don't know how you want to handle questions. So
Oh, I can handle one now, I guess. This is a good time as ever.
you want to just wait till the end or?
Well, how do I have to click things? Because that's not a good idea. I was going to say, Colin, if you want to speak, but I don't know how to allow you.
You can take care of that.
I already allowed everyone to speak, so.
Oh, okay.
they
Just
have to-
unmute yourself.
Colin Heffernan, do you have a question? Okay, I guess not. Harold Thompson, do you have a question? All right, so I guess there are no questions. It just felt like it. And
Excuse me, this is Harold Thompson. I know there's been a big discussion up in Lyme about farming. And so when you talk about the farming regulations and what they can do and what they cannot do, I think that's, for some areas, that's a big issue.
Absolutely.
When you talk about some of the farming regulations don't really take a look at wetlands as such. And they can, sometimes they just move into that and do that. At least this is going back, decades ago, but I'm sure that everyone's more sensitive now. But there's been a big discussion up in the Lyme area, and I'm sure impacts other areas as well, as what the agricultural process and what restrictions there might be. And so how are we dealing with that?
Well, you deal with that through your definition. And if someone's going to claim that they're exempt, they come before you and describe their farming activities, and you decide whether that falls within the definition. Darcy, I don't know if you had anything to add to that, or?
Yeah, so as an inland wetland commission, in some ways you kind of have to put blinders on. Your role is to look at the activity and how's that activity going to adversely impact or affect the inland wetland or watercourse. The legislature has said certain activities can occur without permits. Now, as Attorney Willis said, you have the right to ask for sufficient information and make that determination. And those activities that the legislature has said can occur might be adverse. You might not like it, but the legislature has said they can occur. And so a lot of farming activities fall in that. Inland Wetland Commissions use a definition found in Connecticut General Statutes 1-1Q. That might be repeated in your regulations. Some towns do, some towns don't. The end of that definition actually says that nothing within the definition of farming and agriculture will restrict the power of local zoning. So I do know, and I'm Attorney Willis, maybe you can elaborate on this. I do know that some towns have separate definitions under their zoning. But wetlands should use 1-1Q, and there's no requirement regarding income. There's no requirement regarding, does this have to be a commercial farm? It can be a hobby farm. It could be existing. It could be someone wanting to establish a new operation. We do have guidance on DEEP's website, and I can mail some things. We have an Agriculture, Forestry, and Connecticut's Inland Wetlands and Watercourses Act brochure that kind of walks through this. I'll hold it up. You guys can see it. So you're welcome. I can, if Lynette or Chris wants to email me, I can mail copies, or you can find it online. But you got to think in terms of wetlands and watercourses and your roles and responsibilities under that law.
Well, and I think that's good, but I mean, if a farmer is out plowing his fields, is there a restriction how close he can go to the wetlands? I mean, is he going to follow that guideline? Is he, there's really, I guess it's up to the farmer, isn't it?
Well, it's it's very specific in the statute what is and is not allowed under the Inland Wetlands and Watercourses Act, as far as what activities can be exempt or not exempt for farming. Grazing, farming, nurseries, gardening, harvesting of crops, these are all things that can be considered exempt. Again, there's certain kickouts. If you have to relocate a water course with continual flow in order to graze or garden or harvest your crops, that relocation requires a permit, but not the grazing or the harvesting of crops. We've always recommended at the department, don't frustrate the farming operation. Clearly, the legislature wanted certain farming activities to, operations to be exempt. That's why they put this in here. You're not going to cause someone who needs to harvest and base their haying on, weather to come before you for a permit. But if that operation for some reason caused a wetland to be filled in, that is the regulated activity. If they didn't get a permit for that, perhaps, you might consider enforcement. But no, I mean, it can be very tricky, but I would say, your day-to-day average farming activities, you're not going to have someone stop and come before you.
Now I'll give a different example that's currently on appeal that I'm
Thank you.
waiting for a decision on. And as someone came into a wetlands agency and they had a barn, but as part of that barn, they also had a residence. Now, because of that, there was a need for a wetlands permit. That's what the agency determined. The agency granted the permit. A neighbor appealed. And so that's on, and as part of that appeal, they said, oh, well, we were really exempt. We were just, coming before you as a courtesy. And I don't think that was the case, but we'll see what the judge has to say. So sometimes in these instances, as part of their construction, they were going to have, I believe, 12 stalls for horses and like a unit for like a caretaker. I would call it more like an apartment than a house. So I'm kind of interested in where that ends up getting decided. Your decision-making procedures, hearings and notice. When hearings are required, a public hearing is required on any proposal to adopt or amend the inland wetlands and watercourses regulations or the official boundaries or watercourse designations. Now, I don't know, Darcy, when's the last time you guys came out with model regs? Help me out here.
Oh, darn, you're putting me on the spot. So,
Well, you've been nailing me, so I'm returning this one.
I know. So May 1st, 2006. However, we issued annual advisories. If the legislature tweaked the Inland Wetlands and Watercourses Act, we issued an advisory to towns. So we have all those advisories as well as the model on our website. I did not do an advisory in 2021 when some permit timeframes were changed. And I'm going to wait to the end of this legislative session and just kind of put one out that deals with both 2021 and this year, if there's anything this year. I started to revise the model about 5 years ago, but put it aside for other reasons. And again, I'm going to probably pick that project up again within the year.
Well, one of the more, I guess, tinkered with thing, really, not only with wetlands, but with zoning, are the duration of permits. That depending on when you get your permit granted and when it ends, it can be a short duration, it can be a long duration. So that's something that is pretty much staff and maybe your attorney would have to look at anyway. It can get, I've had people call me up and saying, well, my wetlands permit expired. And I said, well, send me the stuff. And I go, no, you got like plenty of time. And they're like thrilled. They're like, all right, I'm happy now. So, you never know what's going to happen until you actually sit down. And I just wish they'd stop doing that. And just make a flat thing for everybody so everybody knew what the rules were. regardless if there was a downturn in the economy, regardless if there was COVID. These things all make the legislature do things, which I guess I should be happy with, because that means people have to call me up. But you know, it would just, I think it's always good to have a consistent, regular permit duration so everybody knows what's going on. So then your other reasons for having a permit may have to do with an application. All right. So you don't have a public hearing on an application unless the agency determines that the proposed activity may have a significant impact on wetlands or watercourses. That's one. Two, a petition is signed by 25 people who reside in the municipality, and folks have 14 days after the date of receipt of that application to file the petition. That's why in the date of receipt, you're not in a position to really grant a permit. You have to wait to see if somebody files an application to for a public hearing. And the third reason is public interest. And that one's used a fair amount also, where it may be something that's controversial, or it may be something that a lot of people are interested in. And that is a reason to have a public hearing. And so those are the basic reasons for the agency to have a public hearing. So quite often when you get an application in, you're going to need to determine whether the proposed activity may have, and it is a may have, a significant impact on wetlands and watercourses, or whether there's a public interest. You're not going to usually know about a petition until, you know, after the date of receipt. Once in a blue moon, people are aware of it and file the petition anyway. I have not been seeing that many petitions. Usually agencies will use the public interest reason if they think it's going to be controversial, and that's perfectly acceptable. And that's why it's in the statute. So notice of hearings. Adequate notice of the time and place of the hearing must be given. And this is important. This is a jurisdictional issue. A lot of, and I was talking to Darcy yesterday or today or sometime in the recent past about how inland wetlands agencies, you know, some of their things they do is a little mushy. All right. Zoning, it's a little black and white. Inland wetlands, it's a little mushy. And so the one thing that has to get done correctly are the legal notices. And they are still legal notices that are required to be published in newspapers. You know, I could tell you right now, in our office, we can't even get the Hartford Current delivered to us. Our office is in Hartford. You know, we can get the Wall Street Journal, but the ability for newspapers to get circulated has kind of dissipated. Right now, actually, my law partner, Mike Ziska, has an appeal concerning the borough of Fenwick and legal notices. Fenwick, as you know, since this is Old Saybrook, is you know, it's kind of wicked small, so there's not a lot of houses, and there's not a lot of circulation of newspapers. So that is on appeal. And that's with the appellate court. You know, the court is going to have an opportunity because the legislature's been doing nada. So people have been asking the legislature, let's have our legal notice published on the town website, so we're not spending money with the newspapers. Everybody can see it. Nobody gets the papers anymore. And, you know, they don't do anything because the newspapers and the media still has a lot of, you know, clout. So that hasn't changed. I'm hoping that it does. So it's something that all towns can do, and all citizens can go to their town webpage, hopefully, and probably it would be physically posted for those that don't have internet access, obviously, so that people could see when a public hearing is, rather than, you know, in some towns, you know, in some small towns, no newspapers are actually sold in the town. And so there's no convenience store that's selling newspapers. There's no gas station. I mean, it's totally dying out. And at some point, the legislature is going to have to address it. That's why I'm curious to see what the appellate court has to say in the Borough of Fenwick case. It could be a very interesting holding, but we'll have to wait and see. So that notice has to be published twice, having substantial circulation within the town. What does substantial mean? Well, that's going to be an issue to be determined. The notices must be published at intervals of not less than 2 days, with the first notice being published 10 to 15 days prior to the hearing, and the second being published at least 2 days prior to the hearing. You know, in a place like Old Saybrook, you have good staff that manages pretty efficiently, in my personal experience. There's also the public notice requirements are jurisdictional. If there's any personal notices, then that's only applies to the person. It doesn't apply to the decision itself necessarily. Copies of any proposed inland wetlands and water course regulations that are being proposed must be filed with the town clerk 10 days prior to the public hearing. And yes, if someone wants to challenge it, they will go to the town clerk and see if you've filed those proposed regulations. I know because I've done it. So yeah, people do that. And that is something, if you're changing your regs, that happens. There are certain instances where there are non-public notices. So the agency, you know, you have to notify the clerk of an adjoining municipality of any application concerning a project on any site which is within 500 feet of the boundary. There's other reasons too, but that's the big one that clicks it off. Or if there's water runoff that might impact an adjoining municipality. But those are notices that only the adjoining municipality can raise a defect in. It's an important distinction. Also, water company's watershed, the water company has to be given notice within 7 days of the application, provided that the water company has filed a map showing the watershed boundaries, both in the municipality's land records and with the relevant commission. Once in a blue moon, you will see a water company be very interested in an application. Doesn't happen a lot, but it does happen. Time limits. I mean, one of the important things to realize with time limits with wetlands agencies is there's no automatic approval. So someone can't just sit around and wait and go, nana boo-boo, you have to give me a permit automatically. There are some zoning permits where you can get automatic approval, and those are very dangerous things, okay? But for your time limits, you're basically looking at making a decision or commencing a public hearing within 65 days of the date of receipt of your application. The applicant can consent to one or more extensions of this period for a total of 65 days. So that's, if you do decide to have a public hearing, you're going to start it and have it within 65 days. You're going to open it within 65 days. You're going to complete it within 35, and then you have a decision to be made within 35. But you can always ask for extensions up to 65 days. So that extensions are granted usually pretty often if they're requested. Once in a blue moon, you may get an applicant that says, no, I want you to make a decision. So you have to use what's in front of you to make that decision. In my experience, it doesn't usually make the agencies happy. But be that as it may. The local agency is required to mail notice of its decision to the applicant within 15 days and to publish notice of the decision in a paper having general circulation within the town. So again, there's a legal notice published at the end. And that legal notice is important. If the agency fails to do it within the 15-day time period, then the applicant has an extra 10 days to publish a legal notice. And so if the agency doesn't publish the notice, sometimes the applicant does. And I've done that also, where for whatever reason, things happen. And, you know, someone goes on vacation or somebody forgets, or, I mean, I've had it happen where you're scheduled to have a paper, publish a legal notice, you send everything in, you look at the copy, yada, 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 and then they forget and they go, oh, sorry. And it's like, well, these are important. I mean, these are important things to have happen, but I've had people who I sent the notice to, and you'll say, okay, we need this published on such and such a date. And from that day until that date, they've lost their job. So like, oh, there's nobody, you know, there's no continuity. And so I've had to, you know, do some things, legal situations regarding that. Coordination of inland wetlands and water courses applications with other land use applications. All right, so inland wetlands and water courses, you guys come first, all right? Somebody's got to file something with you no later than whatever they're going to file with the zoning or planning commission. So that's a very important aspect of inland wetlands and water courses, because in the end, they're waiting for your decision and or report regarding that final decision that you make. If you fail to do it, it's to submit a report or a decision to planning and zoning. That doesn't mean that the agency's decision is invalid, but you should do it anyway, because they want to know what necessarily you think on an application. And sometimes what happens with wetlands will impact what happens in zoning. So for example, if somebody says, oh, we want to put this building here, you may look at it and say, well, wait a minute, you know, you need to move it 20 feet northwest. You're impacting the wetlands, and it's an impact that's going to damage the wetlands. And so then that might impact zoning's parking regulations or zone, you know, I mean, it's a domino effect. And that is why wetlands goes first. And that's why you guys are the first ones to take a bite of the apple. Now, next, I was going to discuss feasible and prudent alternatives. All right. Basically, if you do decide to have a public hearing, because there's significant impacts, you're going to have to determine whether there's feasible and prudent alternatives. So if there is a significant impact, that's the test that you have to use. The agency may require an applicant, and should require an applicant, to demonstrate the absence of feasible and prudent alternatives by analyzing other methods, utilizing the site, rearranging structures, using less fill, reducing the size of structures, etc. Or even by maybe combining adjacent lots owned by the applicant. So kind of everything's on the table with feasible and prudent alternatives. And it's the burden of the applicant to prove that there is no such alternative. It's not your burden. It's the applicant's burden.
Question. When you say everything's on the table, though, that doesn't mean if someone's coming in for a 3-lot subdivision, that now you can have them do a commercial development or a farm. They still have to stick to what the original intent was, right?
Correct. What I mean by that is your uses that you've proposed. I don't mean that, you know, we're going to have a car racing track after you proposed the automobile. Well, you know, there are a couple of towns left in Connecticut that don't have zoning. And it's very interesting because people get really interested in the inland wetlands in that town because they don't have zoning. And, you know, I represent one of them. And, you know, there's been instances where they call me and I'm like, well, if you guys want to have zoning, you can have zoning. But you know, just because somebody comes in with 10 houses on a lot, you don't have zoning. You've got to, you know, you got to look at whether there's an impact of wetlands. And so it's an interesting thing. And that does also kind of emphasize the difference between the fact that a town has to have wetlands regulations, doesn't have to have zoning or subdivision regulations. You happen to have all of them. Most towns do. It's the rare exception that a town doesn't have zoning and subdivision regulations. So the burden remains with the applicant to prove there's no such reasonable and prudent alternative. All right. A commission may require an applicant to submit evidence regarding feasible and prudent alternatives, even if the applicant doesn't believe there'll be any harm to the water and water courses. You ask for it, they have to provide it, and that's the way it works. An alternative is, quote, feasible, quote, if it's able to be constructed or implemented consistent with sound engineering principles. All right. An alternative is prudent, and I'm taking these from the statute 22A-38, if it is economically and otherwise reasonable in light of the social benefits to be derived from the proposed regulated activity, provided costs may be considered and decided what is prudent, and further provided a mere showing of expense will not necessarily mean an alternative is prudent. And I can give you a little story on this. It wasn't about an application, but it was about an enforcement proceeding. And this was a trial that I had to do in a town where someone did not abide by the Inland Wetlands Agency. And it involved some fill they put down. There was an easy resolution that the violator had agreed to. He said, I'll do this, and I'll do it by this date. Well, lo and behold, he didn't do anything. And he said, you know what people say. And so we had the trial. And during the trial, one of the issues had to do with a garage and whether he could access his garage in the back of his house with his car, and whether he could put his car in the garage. So the judge asked him, well, can you do that? Can you put your car in the garage? He says, oh, no, Your Honor, my Ferrari doesn't fit in there. And so when he said that, and the judge thought the town was giving him a hard time, but the fix was very cheap. And once he said that, I could just see the judge roll his eyes, and I knew that he didn't think that was a very prudent way to approach it. There are other statutory criteria in analyzing any application. Whether or not a hearing is required, the local commission has to consider the following factors. And these are set forth in 22A-41 and presumably also in your regulations. And they are the environmental impact of the proposed regulated activity on wetlands and water courses, feasible and prudent alternatives, the relationship between short-term and long-term impacts of the activity, and the maintenance and enhancement of long-term productivity of such wetlands and water courses. Another factor is irreversible and irretrievable loss of wetland and water course resources that would be caused by the proposed activity. And then that goes on to say to somehow prevent and minimize pollution, the character and degree of injury to, interference with, safety, health, or the reasonable use of the property, which is caused or threatened by the proposed regulated activities, and impacts of the proposed regulated activity on wetlands or water courses outside the area for which the activity is proposed, and future activities associated with it. Now, there's some things that you don't have jurisdiction over. You're an inland wetlands agency. You're not like the EPA. All right, so you don't have any jurisdiction over air pollution. All right, noise, traffic impacts. All right, those are not impacts that the wetlands agency has jurisdiction over. Now, there could be an instance where you have traffic, the traffic may impact something in the wetlands physically because the drainage isn't handled properly. But the mere fact that there may be more traffic somewhere, that's not your issue. And, there are cases concerning people trying to raise air pollution, and, and the courts have held that's not something that the Inland Wetlands Agency can consider. So those are all important things to remember.
I'm gonna jump in again.
Yeah, come on, jump
Um,
on in. I need some
So
water.
oh yeah, okay, I'll talk. These factors for consideration should be repeated in your regulations. In that section of law says including but not limited to. So I do know some town wetland commissions that have actually thrown a few other things into their factors for consideration, but they need to be tied to, I think, what is that adverse impact to wetlands and watercourses. Also, remember that one of the factors you can look at is feasible and prudent alternatives, and just talked about how if you can hold a hearing based on an initial finding that you think this activity is going to be significant, you have certain things you have to do related to feasible and prudent alternatives. A lot of town wetland commissions think that is the only time they can consider feasible and prudent alternatives, is when they hold a hearing based on significance, and that's not the case. It's clearly outlined in your factors for consideration. You can consider feasible and prudent alternatives on all applications. And then I also want to point out that under this section is where you kind of get into mitigation. You need to consider things that will prevent and minimize disturbance. And there's a priority listed. A lot of times I've seen applicants go straight to trying to create wetlands. And the priority is actually restore, enhance, and then create. So when the legislature passed this sentence or two that's listed here, they recognized that creation may not always work. And so they wanted to focus on restoration first, then enhancement, and then creation. Did I give you enough time to get a drink?
Oh yeah, no, I had my water. Yeah, I was losing my voice there a little bit. There are certain statutory things that have been amended to make it clear that wetlands or watercourses includes aquatic, plant, or animal life and habitats in wetlands or watercourses. And habitats means areas or environments on which an organism or biological population normally lives or occurs. So I'll give another example about where things live and how they occur there. We were involved in with an applicant. There's a couple of vernal pools. One of the vernal pools was very productive, had a lot of frog eggs. There's a lot of activity, and so that was recognized. There was another vernal pool that had really degraded, so that was recognized in a different way. But in between the first public hearing and the second public hearing, someone notified the town and said, hey, there's actually frog eggs in that second vernal pool. It's more productive than you think. And so all the experts got together, they went to that vernal pool, and they figured out, because they're experts, that some of the eggs from the first pool had been grabbed and thrown in the second pool to make it look like, unfortunately, that meant that those eggs were not going to make it. So it has to be real. It has to be something that's within that impacts the wetland and watercourse, and you don't want to be tampering with actual productive wetlands and watercourses. And that's a really rare example. I mean, it's the only time I've seen people try to muck around and destroy things. Another amendment included municipal inland wetlands agencies shall not deny or condition an application for a regulated activity in an area outside wetlands or watercourses on the basis of an impact or effect on aquatic, plant, or animal life, unless such activity will likely impact or affect the physical characteristics of such wetlands or watercourses. So that's really what we're always talking about, wetlands and watercourses and the impact upon them. I had one appeal where there had been a condition of a permit that the applicant install very large concrete blocks right on the edge of the wetlands, because I said it was a subdivision, and the agency said, well, those people are going to destroy those wetlands. They're not going to take in, even though they were going to be protected by an open space designation, they're going to destroy them. And the court was very skeptical of that. We ended up settling the case, but it was the only time where I brought a wetlands appeal on behalf of a property owner, and the Attorney General agreed that I was right on one of the issues. They're usually backing the commission. In this case, they backed the property owner, because you can't have something, you can't say, well, yeah, they're going to violate the wetlands regulations, and then we have to do this. It doesn't, that's speculative. You can't do speculative things when you're conditioning the permit. And that's another, you also can't deny an application on the basis of speculative risks, all right? And there is a case on that. It's Riverbend. It had to do with soil mixing. It was something that the court upheld. Now, another important issue, and this happens in both wetlands cases and zoning cases, is that agencies need to have substantial evidence supporting an affirmative finding or harm of potential harm to wetlands and watercourses. That doesn't obviate the applicant's initial burden of submitting sufficient evidence to prove compliance with the regulatory standards, but there must be what's called substantial evidence. And there's a lot of cases on substantial evidence. I'd like to tell you exactly what it is, but it's something that's meaningful, and it's something that isn't just like, well, if you approve this, Johnny's going to move to South Carolina. That's speculative. That is not an impact to a wetlands or watercourse.
So they should stay away from things like I think, or maybe, or I don't like this, I believe, and rely more on this will affect that
Impact,
substantial type impact, this will
destroy,
impact.
impair the wetlands or watercourses. Yeah, I mean, and those are words.
There's scientific information, or right. There has to be more substance to it, not the speculative part.
And if somebody says may, that doesn't mean will. And courts won't be as swayed when an expert says, well, that might happen, because that's speculative. An expert has to say, yes, if you do X, Y, Z, this will happen. And that's an important thing to realize, and it's an important distinction for your own experts to know, because sometimes experts don't like to say things clearly, and that's where you really have to be clear. It's very important. So I'm going to let's see. I'm going to skip a couple pages here. There is an important distinction between an applicant's obligation to provide the necessary information on which the commission may properly decide an application, and the commission's need to rely on specific non-speculative evidence in determining whether a proposed activity will create harmful impacts on wetlands and watercourses. There are cases on that, one of which is Three Levels Corp versus Conservation Commission. A commission had denied an application both for harmful impacts and for lack of required information. The court held that the first reason for denial, and that was the harmful impacts, was inadequate because the commission's experts had only rendered opinions to the effect that some type of harm was likely to result from the activities. So they weren't direct enough. However, they did affirm the denial because the information provided wasn't adequate. And so that really kind of leads to expert witnesses. You don't necessarily have to believe an expert witness. However, if there's only one expert witness in the room and you're not sure you believe them, you better get your own expert. And in Old Saybrook, you do have Ordinance 71, which allows you to get experts and have the applicants pay for that. And it's a whole procedure that you have and that you can utilize. And really you should for applications that have any complexity in them, or anytime that you have an issue. That's very important.
And you know,
and
I want to, sorry, I want to emphasize too, don't be afraid to ask questions.
oh
and,
yeah,
you know, validate their expertise. You know, you can have an engineer talking about soils, and engineers do have to learn about soils, but not necessarily the same way as it applies to determining a wetland soil. So they may not have that expertise to figure out if it's a poorly drained, very poorly drained, alluvial or floodplain soil. So ask questions, establish that on the record, because it's my understanding if something went to court, that's what the judge is looking at, is what that file is. And if they can understand what you asked and the information you received, that could help you. So ask
well,
questions. Don't be afraid to ask questions.
and ask questions while your public hearing's open. So if you have a
Yeah.
public hearing, you want to ask questions while it's open, because you have to give the applicant a chance to respond. That's very important. So many times I've been at hearings where they'll close the public hearing. We're all done. Nobody asks questions. It's all yada, yada, yada. And then they'll go into deliberations. And then they say, well, I have a question. And it's, oh, well, ask, you should have done that while the public hearing is open. Don't do it now. So anytime you have a question, do it while the public hearing is open. If you don't have a public hearing, that's a little different because you can ask it. But the other part is if you have a particular expertise that you're relying upon, you have to disclose it to the applicant. And that's a very important thing to do. Let's say you're an engineer or a soil scientist or whatever it might be, and you have some expertise regarding an issue that might come up. You have to disclose that because the applicant isn't going to know that automatically. It's a matter of fundamental fairness. And I know that one agency I used to represent had a soil scientist, a botanist, and I forget what else. They had like an engineer. They had all these people on their agency, and the staff member would put their resumes into the record every single application. Now that agency happened to be very close to Mansfield and the University of Connecticut, but it can happen in any town. I'm amazed at people's expertise in different items. Just disclose it on the record.
And the department's always recommended that as well, that you just get into the habit, if you have experts that sit on the commission, that you put a resume or some sort of statement of expertise, in the record of each application, even if you've seen that same applicant, oh, they know me. No, because if a judge is going to review the file, they don't know them. They don't know who you are. So make sure just maybe get into the habit of putting that resume in the record of every application. Then if you need to rely on expertise of a commission member, you got it there, you're covered.
All right. Conditions on permits. You are allowed, the statutes specifically say that you can condition or modify a permit. Such terms may include any reasonable measures which would mitigate the impacts of the regulated activity and which would prevent or minimize pollution or other environmental damage, maintain or enhance existing environmental quality, or in the following order of priority, restore, enhance, and create productive wetlands or watercourses resources. And I know that Darcy had mentioned that earlier, and that's specifically in the statute. There are certain time frames for permits. We kind of briefly talked about that. Just like Darcy said, I'm waiting to see if the legislature does anything this year. It's been so much in flux with permits and their duration. Fortunately, the Inland Wetlands Act has not been eviscerated like 8-2 of the Zoning Act by the General Assembly. Permits cannot be made personal to an applicant. It can't condition a permit on just one person. Permits do run with the land. And so that's important to realize.
Can I
Statement
throw
of,
some things in there about
Absolutely.
conditions or maybe more a question? So if you are looking at a request for a jurisdictional ruling, and when I say jurisdictional ruling, I mean someone says, hey, I'm exempt. Can you review my activity and rule, yes, I meet the words of the law, I'm exempt. Once you've ruled that activity is exempt, it's either as of right or non-regulated, you've ruled it's not within your authority. So you can't condition it. There's nothing to condition. Now, can you try to ask questions and say, hey, we'll use best management practices? Can you work with staff and let them know when you're going to start the activity? You know, there's some courtesy there. Maybe you can work that out, but there's no permit. So you cannot condition an exempt ruling.
statement of reasons. So 22A-42A requires inland wetlands and watercourses agencies to state their reasons for changing any inland wetlands or watercourses regulations or boundary, any decision to grant, deny, or limit any permit for a regulated activity. If you don't state your reasons, the court will have to review the record to see if there's substantial evidence. Permits issued by the enforcement officer, you are permitted to allow your agent to grant certain permits under the statute, and the authority to approve or extend an activity that is not located in a wetland or watercourse when such agent finds that the conduct of such activity would result in no greater than a minimal impact, and the agent has to have completed the comprehensive training program, and it has to be in your regulations. Notice of decisions have to be published, because that's when people know they have the time to appeal, and that's 15 days. And those are important things, because if you don't appeal within that 15 days, then you are out of luck. It's subject to dismissal in court. Now, enforcement. There are methods to enforce. There's cease and desist that you can issue. You have to have a 10 days within the issuance of an order. You have to hold a hearing to give people an opportunity to show cause why the order should not remain in effect. So those are kind of quick timeframes. A lot of times people ask for extensions on those, but that's an important thing to realize. If a cease and desist order is issued, the landowner has to appeal it in order to the agency, in order to preserve whatever rights they may have. Those rights include exemption rights. There are a couple of cases on that, one of which was Jorgensen versus Chapdelaine, which was a very long and tedious and difficult case. But when an agency files an enforcement lawsuit and seeks injunctive relief in the form of a specific remediation plan, you want to set that forth. These factors will include the cost and purpose of the remedial actions. So if you do have an order and you do have a hearing and you do issue, you uphold an order about a specific remediation plan, you have to make sure that's out there and somebody knows what it is. Because if you don't, then getting that enforced by the court is very difficult.
Can you explain the difference between the public hearing and the show cause hearing under enforcement? Because I think some towns sometimes get confused and they think the enforcement show cause hearing is a public hearing. Is it?
Well, that's up to the agency. I mean, some agencies hold, if it is a show cause hearing, they only want to hear from the violator or themselves. There's no prohibition, I don't feel, that a neighbor can't testify or someone who saw but that's a judgment call by the agency. A public hearing is one where everybody gets to talk if they want to and come before the agency and they say, I'm so-and-so, this is where I live. this is what I think. And even if somebody comes from out of town, God forbid, they're allowed to speak at a public hearing. I've been in some instances where people say, oh, you know, they're not from town, we can't let them talk. No. Public hearings are for everybody. Everybody's a member of the public. It's important to realize that. I've never seen that to be a problem in Old Saybrook. I have seen that be a problem in other towns where they think that the public stops at their boundary line. So that's always a little scary. So appeals, people can appeal your decisions. It's important to lay a record for your decisions. And that means setting forth what your reasons are, but it also means getting the evidence that you need to uphold your decision. And that evidence may be from an expert, one of your own experts. It may be the fact that someone's has an incomplete application and you can't actually make certain determinations about wetlands and watercourses. But that's important that you have evidence. It's always a little different because you don't think of yourself as like a mini court, but you are an administrative agency. You do need to rely on evidence. The court just looks at whatever is quote called the return of record. So the return of record is whatever is submitted to the town or to your agency and their staff regarding a permit or application. And so it starts with that filing. If any experts file anything, any members of the public, it all becomes part of the return of record. And then there's a transcript made of the public hearing and of your deliberations and decision. And it's important to lay your reasons out in that. It's important to speak clearly so that you can get transcribed because that is what happens is that those matters are transcribed. I imagine maybe someday, not soon because it's the court system, they may rely upon videos of public hearings and deliberations. However, I think they still like transcripts because it's what's actually said. And saying that means that when you're speaking and you know you're being recorded, you have to be careful that you don't make jokes that if you read it on a transcript might not seem right. So, you know, you have to be careful that the transcript doesn't pick up your reflection or, you know, the manner in which you're speaking. So you want to be really clear about your questions, how they're answered. And if you make jokes, they should be ones that are very clear to understand. Darcy?
And likewise, be very clear with your emotions.
As
Right?
clear as you can be. You want to be clear with your emotions, you want to state your reasons, and you want to have the evidence to support your motion. That's all very important. I know we're bumping.
And that's,
oh, go ahead. I'm sorry, Darcy.
I was gonna say, and that's why I said it's questions are never bad to ask. There's never a dumb question. And this is a complicated law. And so ask the questions. And again, the burden is on the applicant to prove to you.
Always ask those questions when the public hearing's open, if there is one. That's very important. I did come up with an inland wetlands and watercourses joke. I don't know if everybody's ready for it. How many soil scientists does it take to screw in a light bulb? None, because
How many?
they're always busy out in the field. That's the best I could come up with.
Heard worse. Heard worse.
No, I know. That's all I could. There's not a lot of inland wetlands jokes. I couldn't find them on the internet. So I came up with
It should be a dirty joke.
well, yeah, but those are the
Yeah,
kinds I
I
have to
know.
avoid, just so you know.
Yeah, no, just saying.
Especially with
the
taped
soil-
proceedings.
The soil scientists out there will say it's soil. It's not dirt. Dirt is
fair
something you
enough,
find
fair,
on the
fair.
floor of your house.
Okay, fair.
I don't know if anybody has any questions. I mean, that ends my
Yes,
presentation, but yep, go ahead.
Yes,
Hi, Chief Gulwick, I'm a member of the commission.
Okay.
Julia, I got a lot of questions, but I don't want to burden the group for another hour. So I'll just leave it to a couple. Wetlands definition is pretty clear, soil type. On water courses, is there a distinction between freshwater,
And so on.
estuary, and saltwater?
Well, if something's tidal, then you don't have jurisdiction over it. So, I mean, I think that's the big distinction that you would have to deal with. Darcy, did you want to say something?
Yeah, so there's a separate Tidal Wetlands Act, and there's a separate definition for tidal wetlands. And as was just said, it's based on, you know, vegetation that can live in high salinity environments. It's based on hydrology and to some extent some of the soils, but it is a different definition than inland wetlands. As far as having two definitions, I always tell people the definition of wetlands says wetlands are land. That's right up front, including submerged land that then consists of those types of soils. So wetlands don't have to be wet. Think of a pond, the submerged soil is the very poorly drained soil. That's maybe the wetland part. The water part is the water course. That's kind of how I tell people who are new to this to think about it. There may be wetland soils around the edge of that pond that are very poorly drained, or maybe around a river that are floodplain soils. So they overlap. For example, with vernal pools, if a vernal pool's been there long enough, the center of that vernal pool may have experienced the chemical changes that an environment that's constantly wet experiences, and might be able to be delineated as a poorly drained soil. But the vernal pool is not just the center of that vernal pool. Vernal pool is much larger, and that's why vernal pools fit under the definition of water course as well. So there is overlap. The water courses definition uses more commonly understood terms, and the wetland definition is based on soil science, a scientific system of classifying soils.
So
I don't know if I answered.
am I talking?
Did I answer your question?
Sort of. Okay, but
Help me out.
But a water course is distinct from a wetland. Meaning, I'll give you an example right here in Saybrook. We've got the Oyster River, okay, which is on the west side of town. There's a portion of the Oyster River which is clearly freshwater. It's not impacted by Long Island Sound or the estuary at all. Then there's the estuarine part, which is brackish, if you will. And then there's the part that is purely salt water. Where does our jurisdiction?
Okay, the Watrous court case. Are you familiar with that, Attorney Willis? So there is a court case some time ago. It was done through the federal courts. Didn't quite give us a solid answer, but basically, there was an Inland Wetland Commission that was looking at activities that were adjacent to a tidal water course, and they recognized that the water course was tidal. They recognized that the edges of the water course had tidal wetlands, and so that fell under the jurisdiction of DEP. But what they wanted to do was apply their upland review area to that water course, and therefore regulate a house that was going to be built partly into that upland review area. The end result, I believe, of that court case said that the jurisdictional boundary for regulatory purposes, of that town was at mean high water. Because that's a tidally influenced water course, there's the public trust doctrine that anything below mean high water is in the public trust. And so your town boundary, in essence, again, just for regulatory purposes, ended at mean high water. So the water course was outside of the town's jurisdiction, and therefore they could not apply their upland review area to it. It gets complicated. Consult with your town attorney. But
and experts, there are lines that get there are lines that get drawn, and so that's where you need evidence. I mean, that's really that's a good question, but you need the evidence of an expert to say, here's the inland wetland and water course, but here's the part that's tidal. And and they don't always agree. So, you know, I mean, that does happen, but,
That goes to the other definition that's used within Connecticut environmental law, and that's the waters of the state. And who actually has jurisdiction over it, as you pointed out. Right.
The public doctrine, right?
Public doctrine.
Right. And there have been situations where, for example, tide gates or small dams have stopped that salinity or that flow of water. And so therefore upland from or inland from that tide gate or a small dam has become a freshwater system. But below it is a tidal water course and would be under DEEP's authority, tidal wetland system. So there are situations like that. You can always contact the DEP too for information when you're confused about that. But I agree, the expert should be providing that information to you.
that's important information, and DEEP will let you know when they think it's tidal wetlands. That's been my experience.
Another question you brought up before about the content of a public hearing and the record that has to be submitted. So that if a member of the commission has got some expertise and is reviewing the application, that should be in some way articulated, maybe through the town planning department, okay, and providing those comments so that that is entered on the record, correct?
Well, yeah, yes. I mean, you always want that to happen anyway. So say, for example, whatever, you're a soil scientist, okay? And you're on the commission and you see an application and you go, well, I don't think the soils there, I think they are wetlands, not like you've marked them. And just so you know, I am a soil scientist. So that you've given that information to the applicant, you've done so during the public hearing, or if somebody's an engineer, they might say whatever they want to say. But yeah, you want to say that or provide it to the applicant while the public hearing is open. You don't want to add things to the record after the record is closed that are new facts.
Would it be sufficient to, during the roll call that we do at the beginning of every meeting, to announce the professional credentials of such a professional member at the end? So if I could say, Colin Heffernan, Esquire, or I could say, so-and-so, public engineer, PhD in soil science, and I could just make that part of my routine. And that way I'm covered and the chairman can just take care of it and then it's good.
You could do it that way. I would prefer that you do it at the start of every public hearing. And I'm sorry to say that, but when I get things transcribed, sometimes they don't, so you could have a really long agenda.
Yep.
And they don't transcribe the whole thing. They're only just transcribing what's on appeal. So I prefer it, if you're going to use your expertise, you disclose it while a public hearing is open or while an application is being discussed.
So maybe only for public hearings or for any application?
Any application that you're going to use your expertise.
Okay.
That's why I say get in the habit of just submitting your resume, because I do know a lot of towns will have multiple public hearings for different applications on their agenda. So you would have to do that literally every time they, on that same evening, you would have to make that announcement at the start of every hearing, depending, for the application that you're hearing on. So if you can just get into the habit of submitting your resume into that file, it probably wouldn't hurt to make that statement as well for the members of the public that are there, that maybe didn't see the file, but that gives the applicant the ability to, and if there's interveners, the ability to cross-examine you, ask you questions.
All right.
Thank you.
One more. Part of our regulations say that the commission has at its discretion to require performance bonding. I would suspect that probably has to do with post-construction maintenance of any appurtenances or whatever that are being included to control the flow of stormwater and protect the wetland, like catch basins, swirl separators, detention ponds. What kind of discretion does the commission have to require that?
Well, it has to be directly related to the wetlands. And so that's an important thing. Bonding, you usually run something by your engineer. They'll give you quotes as to what the bonding amount should be for a particular project. But yeah, you're a little, you're limited to what's going to happen to the wetlands. And how long will this certain structure or facility exist? You can't have performance bonding forever. So, I mean, I think that's something to realize.
Can you have
So
performance
can you,
operating costs? Meaning the example is if you've got a development that's all of stormwater is going into a retention pond for peak flow control and to remove turbidity and solids, and then that discharges into the wetland. There's a certain amount of upkeep and maintenance required to keep that a functional feature.
And usually what's going to occur is that you'll have a condition requiring that. If that is going to be a private facility, you're not really in the position to bond it. If it's a public one, you can. That's usually where the line is drawn. But quite often for drainage structures, you might set, you might have a maintenance plan that's submitted, something to that effect. So that's really what you're talking about there.
But there's a cost associated with doing that maintenance plan on ongoing.
Absolutely. Yeah, I mean, the courts don't like perpetual bonds. That's really the story behind that. And there's been cases on it. And it is a limited function of what you can do. So normally you get a quote from your engineer, the engineers work it out, you have the bond posted, and you go from there.
Okay.
I think there were some more questions.
Got one. Can you hear me?
Yes.
I have a question. I'm staff to the commission, Lynette Wacker. Can you elaborate a little bit on the prudent alternatives as far as the economic evidence that they have to provide that something's not a viable option because they won't be able to get a reasonable return from their investment?
Well, that's always a judgment call. That's something they should submit into the record as to what they feel is prudent and why. They can't just say, well, we can't afford it, because honestly, that's what just about everybody says, is that they can't afford it. So the mere fact that something costs something doesn't mean that it's not prudent. It has to be something that would be substantial. So they might show you, okay, we can do it this way, it costs X, we can do it this other way, it costs Y. Y is a lot more, and they tell you what they think it is. And so that's something for you to analyze. And it may also be something for your own engineer or expert to analyze. Is this all legit? Are we being told something that is an actual cost that could make something not prudent? I mean, I think that's
More often it's something like, if we can't build 75,000 square feet of commercial space, this isn't going to make sense for us to do economically. Any less than that, and we just can't do the project.
Yeah, I mean, there are instances where people say that, but really when you're talking about whether something's prudent, you're really talking about impacts to the wetlands and things of that nature. It's people are always going to say, I have to build, almost always in my experience, I have to build this, or I won't be able to do anything because that's the way it is. They have to provide more evidence than that. There's almost always prudent alternatives to X number of square footage, or they'll say something that happens a lot is, well, we're building this for the XYZ Corporation and they have their criteria. And if we don't meet that, we can't build it. Well, that's not, they have to meet the burden of your regulations. You don't have to meet their burdens. That's really what you have to remember. And like I said before, different inland wetlands agencies might see the same application and have different decisions. I mean, that's one of the things that's a little different from a wetlands agency than from a zoning agency. Most of the time, the zoning regulations are a little more black or white, most of the time, not always. And the wetlands agencies, they are talking about impacts to wetlands. So, you know, if something doesn't really have an impact on wetlands, sometimes people try to use the wetlands agency to thwart a project that actually doesn't have an impact on a wetland. So, I mean, it's a balancing act. There's no, for any particular application, that's why you listen to the evidence. That's why you have experts to, you know, to do a reality check.
And we can ask them to provide financial evidence that they can't do it any smaller.
You could, why not? If they're going to say the only thing we can do is this, then they have to give you evidence of why that's the only thing they can do. You know, I don't know that they have to give you their corporate tax returns or anything like that, but they have to say why they feel something is prudent.
So I had I had an example about prudent. Hopefully this is an example. I remember a town calling me once, and there was something that had been washed out, like a driveway, private driveway to two houses, and they just wanted to put the culvert back. And the commission was insisting that it be an elaborate bridge. And for these two properties that were not very, you know, I guess the people weren't very well off. It was quite the expense. And the result was like an open arch culvert to maintain the natural stream bottom. So it wasn't in a corrugated pipe, but it wasn't a bridge, because the bridge was not going to be prudent for them financially. You know, they couldn't do that. So I don't know if that's a good example.
I think it is. I think that's a good example. I mean,
Where Lynette's going with this is almost every developer that comes in has some economic reason that, you know, if we ask for something that, you know, it's making it economically, it's not going to be feasible and it's going to destroy the project. And there's been situations, you know, where we've had, well, what's the reasonable and prudent alternative? And the applicant goes, oh, well, we could do nothing and it would be better for the environment. And I think it's trying to figure out, you know, to what point do you push it? I mean, we've never had someone come in, you know, with a whole environment or economic analysis of how much money they're losing, but it's developers, especially commercial industrial developers, they want to maximize the profits. So how does the commission, you know, handle that, and what are the right questions to ask to get that information? Because no developer wants to reduce the size of the building or, you know, have one less tenant. I mean, how's that balance in? And I think the commission members too feel uncomfortable. Well, okay, it's not economically feasible. You know, they say, how much are you going to lose? I mean, it's tough. So I'm not sure if there's any additional guidance.
well, sometimes you have to ask tough questions. I mean, I think that's really what it comes down to. If you're saying, no, I need whatever, you know, 50,000 square feet, or I can't build this, and it's like, well, why can't you build 45,000? And usually the answer is, oh, well, the such and such corporation doesn't permit that size. I mean, that's not really an answer. So, I mean, it's one that you can, you have to push applicants on. It's their burden. They have to establish it, and they have to establish it with evidence.
Sometimes what we run into is, especially in Old Saybrook, where there's really not much land to develop left in Old Saybrook. You know, there's not a lot of fresh land, and when we do find it coming into impacting wetlands, it's, if you are looking to buy a parcel, or you have bought a parcel with hoping to develop this, isn't that ultimately your business decision that you made, buying a compromised parcel or a parcel that has impacts? And yeah, maybe you won't turn, maybe this parcel is not developable so you can turn a profit. It's not our problem. Our job is to look out for the wetlands, not to make sure that the business decision you made makes you money.
Well, it's not, if someone has purchased a lot and they've done so, and then they come to you and they say, well, this isn't prudent because I bought this lot for X. And it's like, well, you know, you could have come to us to get an approval before you bought it. Number one, and number two, that's not really part of what is impacting the wetlands. So you're really talking about what is the activity impacting the wetlands, and what is prudent and feasible about that activity.
Unfortunately, you know, I've discovered over the years that realtors don't always convey, you know, the information about wetlands that might be on a lot, and the permitting requirements that might be there. I've actually received over the years plenty of calls from people who are interested in buying certain land or certain lot, and they go straight to the state to say, okay, what's the Inland Wetlands and Watercourses Act all about? You know, how do I have to work with the town? You know, what are the definitions? Because they're doing their research before they buy it. That's part of the process. But I agree, you have to ask hard questions sometimes. And there's a sense of reasonableness, like the example I gave was the bridge, you know, all or nothing, you have to have the bridge. Well, no, they came to a reasonable compromise of an open bottom arch culvert, through asking questions and really, you know, seeing what could be done. And I don't know if there's not one good answer that fits all applications. It's case by case.
A question. Hello?
Hello?
Yes.
Yeah, I have a question. I mean, one of the questions I have is, has to deal with legal notifications. It's like newspapers today are just slimmer and slimmer. And we are required to post these things, notifications in newspapers. But I'm not sure that many people really read them or see them. And so, how do we deal with that?
Well, in some towns, they will put on their website, notice of a hearing, notice of certain applications.
The CT Examiner or something like that. But who's got that? You have to have email, you've got an internet. There's a lot of people that don't have time to look at that.
Yeah, it's like any other notice. If you're not used to looking for them, you don't look for them. But
yeah, you don't see them.
yeah, no,
I can
go ahead.
I can tell you
Darcy.
though, if there's something going on in a neighborhood, the word's going to get around. People are going to look for it. That's often, you know, what happens.
Well, not necessarily. I mean, we've got stuff going on in our town, different sections on, you know, the people that keep me informed are people in town hall. Because they look at all these different websites and they look at it. I don't have time to look at all this stuff. And I think that people who are residents in different areas have zero time. They don't look at this stuff until it comes to the door. And so I think we got a problem there.
So I know with COVID,
I don't want to
oh,
solve it,
sorry.
but I think we have a problem.
If I may, I have noticed that there are often big signs on the property saying that an issue is before inland wetlands or a public hearing. So I don't know.
Where is that? Where is that?
But and I've seen it in Essex also, so that's helped.
So I believe that is a requirement of Connecticut General Statutes 8-7D. If my memory is serving me right here, which is referenced in the Inland Wetlands and Watercourses Act, and that's how you are to conduct your hearings. That's your notice requirements. And I thought in there, I'm actually trying to pull it up online right now to look at it. I thought there was an option to post on the property.
Some towns have regulations that require that. They'll require posting of a public hearing.
I don't think our town does, but
Chris, do you want to comment on it?
I know Old Saybrook does for the Wetlands Commission and some towns do, so maybe you should talk to the staff in your town about doing that, maybe changing your regs. But the one question that I have, or maybe I think we need to touch on, is we really haven't had in a very long time any type of environmental intervention. Is that something we just can talk about for a few minutes? I know, we have applicants who are always like rushing to get things on the agenda, have them the first night, so that's the notice.
Yep.
For environmental intervention, but we really haven't had one. It might be good just to spend a few minutes, especially because I suspect we're going to have larger, more controversial applications coming in that, just a quick little rundown on that may be helpful.
Sure. 22A-19 provides that any person can file an intervention regarding a proceeding, basically before a land use agency. That includes the Inland Wetlands Agency. I don't know how often you get interventions, but that is a verified pleading. So what that means is that it's a basically an affidavit where somebody says, this is what's going to happen, X, Y, Z, and I swear this is true. And they may provide with that an expert's report, or they may not. But that means that that person becomes a party. It also means whenever you get an intervention, you want to make sure, you call your attorney so they can help you through that process. But it's almost like they're an applicant, but they're not. They're a party to the proceeding. And so they can speak just like the applicant can speak, even if there isn't a public hearing. So that is a specialized document and form. It creates certain burdens for the commission and really the applicant. But in wetlands, a lot of those, it really comes down to feasible and prudent alternatives, which is what you're dealing with anyway. But it also only can be filed regarding what you have jurisdiction over. So for example, there was an intervention filed in a matter where someone said, this project's going to create unreasonable pollution, air pollution. And the court said, well, no, this agency doesn't have, that's all controlled by the state of Connecticut. They have exclusive jurisdiction. You in the Wetlands Agency have no jurisdiction over it. So you can't consider that even though somebody's filed an intervention. So, I mean, that's kind of the short rundown, Chris, of interventions and what they do.
No, it's more of a question of the people being notified about stuff. I mean,
Well, that's actually, if you let me finish my other half of the question.
All
So
right.
the thing is that procedurally, what we've done in Old Saybrook is the first night we receive an application and it's received at the first meeting, and we've always immediately put it on the agenda, if it's in there within a week or so, and that served as our notice to anyone who wants to intervene. So the part of that that's a little difficult is that if an application comes in, the commission then has a presentation, they want to see if it's complete, go forward with it, but sometimes there's not enough time to do that, and we have 65 days to schedule a public hearing. So is there a way that we could go through to make that notice and just put a notice actually on the agenda where we say, this is the following agenda, and then just, notice we have received the following applications, to be heard at the next meeting? It's tough because our applicants are always pushing, I need to get on the agenda, and the commission's been very, very accommodating. But when we get very large, complex applications, I don't know if it's necessarily the best thing to rush, to put it on and not give the Wetlands Commission enough time and its staff.
So Chris, if I understand correctly, so the date of receipt is the day of the next regularly scheduled meeting following submission, or 35 days or some other additional language in there. So if your meeting, let's say, is a Thursday, right, night, and someone came in yesterday and submitted an application to the office, they're saying, I gotta be put on the agenda for tomorrow night. It's
Well,
the day
it's-
in the next regularly scheduled meeting.
They try to, but it's still technically received. So maybe it's a week before. Because it's submitted before, and my understanding, and this happened to this commission many years ago, where someone pretty much came in the night of the meeting and said, here's your application. It's here before the meeting, it's received.
Well, that one wouldn't be because it's the night of, but because it has to be the day of the next regularly scheduled meeting. So that one wouldn't be formally received until the next month. Am I correct on that? Attorney Willis?
Yes, the next meeting,
Yeah.
next regularly scheduled meeting
Right.
or 35 days. I mean, I think, Chris, one of the things that Mr. Thompson is referencing is, notice, some regulation have notices to abutters or something like that. But the fact of the matter is, most towns do put things online now. They used to not, so people really didn't know if there wasn't a legal notice for a public hearing or a sign or notices to abutters.
Right, and I get that, and I guess my question started going down a different avenue, and maybe I know the answers to some of the questions, but I'm asking the questions because we have applicants who come in who say, no, I can bring this right up to the night of the hearing, and that's what they tell the commission and staff. So maybe,
So I don't have the legal advice, but I can tell you what I've heard other towns do and talk to them about. So again, the data receipt is the day of the next regularly scheduled meeting. So if they're coming in that day, that if they came in today or this evening, it's not received or, during the meeting. It's received next month at the next meeting. If they came in yesterday, yes, the data receipt could be this meeting, but a lot of towns have an internal process, or they even put it into the regulations that applicants have to submit things to the office at least 15 days before a regularly scheduled meeting. I don't know how that pans out in court. I do know that a lot of towns.
It doesn't change the data receipt.
no,
That's
Right.
usually used as an administrative hurdle to keep people in line.
it doesn't,
Right.
it doesn't work with persistent applicants who are gonna
Right.
dump things off. So I'm asking these questions just to kind of
So
get this into
Well,
the.
I think the answer really is, don't be rushed into doing something.
Right.
If somebody comes in front of you and says, we need a decision on this because it's the end of the world, they still have to meet their burdens, and you still have to have an opportunity to actually review the applications. And if it's a complex one, you probably want the time to do that. So you don't want to be forced to do that. And that is why agencies develop these little rules of, you got to give it to us 7 days ahead. If you want to appear on the agenda kind of stuff.
And I mean, we do that, but what happens is the rush ends up being a very poorly put together application, and then the commission ends up continuing to make sure that everything's perfect because they're working on it and they're going to fix it and they're going to fix it. And I think,
So-
that's
Okay,
where
so-
I'm going with the scheduling and maybe some other examples of other towns. I mean, obviously, when you accept it, it's complete, but sometimes there may be something hidden in there, like missing drainage that we didn't find that skews the whole project. I mean, at what point, does the commission say no?
So I
or-
do start, so I'm going to jump in. I do know, I hear exactly what you're saying, and I do know that towns struggle with this all the time. I hear that same question. So if they are able to get their application in the day before the meeting, I do know some towns that have sort of an agenda item of, like you said, applications received, but because it came in the day before, they'll formally receive it at that meeting, but they haven't had time to let the staff haven't looked at it, haven't reviewed it, so now they have a month to review it. Really, the burden is on the applicant, and you have to go through your process. You shouldn't be rushed. You have the right to ask questions, to have the time to review it. They can give you an extension, right? You can get more time. You can get an extension, but ultimately, if if they're trying to rush something through the process that's not complete, that does not meet your regulations, your application requirements, then it's an incomplete application.
And
So-
that can be your decision. You could say, we're just denying this because it's incomplete.
So if you have an application that comes in 2 days before, it doesn't make it onto the agenda, which normally I think the process with our wetlands commission is because we've always tried, we meet once a month, so to try to get notice to anyone who may want to intervene, you know, for environmental concerns, is it was always put on the agenda, you know, as soon as possible so that we got that notice out and then reviewed, is it significant, looking at it, you know, to if it's, which is a rush to go through and look at it and review it for completeness. Is there a way to notify, other than putting on the agenda or making notice to someone who may want to intervene, that that notice has been received? And the only way we've done that in the past is by putting it on an agenda. I mean, is there a way we can say, you know, at the end of a regular meeting agenda, you know, the following applications have been received in the office, so that there's that timeline, so the commission, you don't have to make it go out 3 months.
You could put that on your agenda that, you know, I mean, the thing is, you got to get your agendas up there. You guys do hybrids, so you're talking 2 business days. So, you know, you'd have to do an agenda. If you put a notice online that, yeah, we received this application, you have some timing issues. If it's all in person, then you're talking 24 hours.
No, I'm saying to extend it to say, rather than put it right on the agenda within 2 weeks, we say, look, we as staff need the time to review this. And we know it's significant. We know this is going on with the application, or we think, you know, we need more time. So it's always been our notice to interveners has been, it's on the agenda. So if we don't,
So
put,
I don't understand the notice to interveners thing you're bringing up, Chris. If somebody isn't an intervener until they file, you don't have any additional requirements to the public.
I guess I'm wording it wrong, is that
Okay.
we have to give some notice that the application has been filed in the office, so that someone could intervene within the 14 days.
So not filed in the office, not submitted to the office. That starts when you get the data receipt. So I think if I hear you correctly, if something comes in 24 hours before the meeting, it does get a data receipt at that meeting.
But it's
That
not,
then starts your clock ticking. And I understand that you have to get your agenda printed or out, and things might come in between that point and the meeting and still be able to be formally received. So I think having a kind of, I don't know what the legalities of this are, but an open-ended, you know, agenda item that just says applications received after agenda was printed or something like that, and you announce what applications were received. But then, yes, recognize that, hey, these applications came in at such a last minute, staff haven't even had time to look at them. We will be reviewing them over the next month and, you know, discuss them at the next month's meeting. And again, if you don't have time to get everything done,
and
the
again,
applicant
it's
can
what I'm trying
grant an
to,
extension.
I think we're on the same page. It's just been,
Yeah.
if an application comes in, even if it's 2 weeks, I mean, if it's a 500 lot subdivision, we're not going to be able to review it for completeness in 2 weeks. So it's always been the application comes in, it's received, and it's put on the agenda if it's within that 2 weeks or a week, and then the commission has a discussion. So holding off and waiting, you know, say we said, okay, this application's here. We don't want to put it on an agenda to April to even have the discussion, because we need as staff to review this to see if it's complete. Because we're
But
not.
that would be what you would say that night. You would say that probably in the meeting. You would say this application came in after we printed the agenda. It's formally received tonight, but there's been no time to review. We're assigning staff to review this, and we will discuss this at the next meeting.
So how does that inform anyone who's interested? Because it's not on the agenda, it would only be in the minutes. I guess I'm just trying to say, how do we get the word out? I mean, is there a way we can, okay.
The only other way you're going to do it is putting things on your website. There's no there's no mechanism, legal mechanism to, I know what you're saying, Chris. There's no legal mechanism if people file something so close to the deadline. I mean, that's just the reality.
But it,
Um,
by the same token, if you're not really going to be discussing it and delving into it until the next meeting, I mean, is that going to be really bad for an intervener anyway? I mean, that they would have, that's when they're going to get involved anyway, or they're going to hear about it at that next meeting and then immediately get involved. I mean, I don't know if they're losing any time, I guess is what I'm saying, for intervention.
I have a
And
question.
correct me if
I guess
I'm wrong, attorney.
I guess where
Go
I'm
ahead.
going is how do we say, okay, we have an application, it's not on the agenda, it was received, we have 65 days to have that hearing, and rather than put it on the first agenda, which in some cases, I think we should put on the next agenda to give us enough time in that 65 is what's the best way to get this notice to people who may want to intervene.
Bingo.
In our agenda, that, you know what I'm saying, that's been the way we put that notice. So is there a different way that we can do it and still satisfy that requirement?
I mean, you could put something on your website whenever you want when you receive an application.
And that would satisfy the notice requirement to anyone who
But you
wants.
don't,
There is no notice
I'm getting,
requirement.
there's no notice requirement.
Yeah, there's no additional notice requirement. Let me put it that way.
So it's just the agenda.
Right. And then if you decide you have a public hearing, you know, then there's going to be other notices, but there's no additional notice requirement to merely receive an application.
I
And
guess I'm just overthinking it because it's something that.
Well-
I think,
Hold on, and I've just
Yeah.
thought it for years.
and there's no notice requirement to the intervener. You don't have to go out of your way to make
Posted,
sure
I guess.
people know that might want to intervene. There's no notice requirement needed. I mean, they're going to learn about it through minutes or through, you know, neighborhood discussions or things like that.
or by
Um,
calling the land use
After-
office many times a week. I mean, there's different ways that
Yeah.
people find out about applications. And sometimes if they know one's coming down the pike, they'll call the town and say, hey, you get an application, you know, I mean,
So I'm just gonna do a hypothetical. We get an application. The application's received, it never makes it onto the agenda. The next meeting, it goes on to the agenda. And it's there and posted, never been posted before. Can the commission act on it?
if the date of
Well-
receipt was the prior meeting, then yes, they could.
But it would be the only night, if it wasn't a significant activity, that anyone would
I
have
guess-
known about that would be the night that they act on it. And I guess that's why we've always done it in 2 meetings.
So Chris, let me ask you this. Even if it came in at the last minute, was some announcement made during that first meeting that these applications came in at the last minute, they get the formal date of receipt tonight?
Well,
Is
no,
there some announcement made so it's in the minutes?
No,
the date of
There
receipt?
probably should be.
I guess I guess we could talk about it a little more versus keeping it.
Yeah.
Yeah, I mean,
I guess what I'm
Comments,
saying,
it's-
yeah.
it's 9:07 and I'm starting to sundown, so
Yeah.
What, may I ask a question on the timing? It's the flip of what you've been discussing. The application is received and on the agenda. The commission, it's a simple request. The commission is ready to make a decision on it. Is there anything legally that prevents the commission from acting at that one meeting, making a decision? and
Yes.
then
This is
publish-
exactly my flip.
Right,
yeah, there has to be 14 days that you wait so someone can file perhaps a petition for a public hearing. So the first time it appears on your agenda, you can't make a decision on it. Now that doesn't mean that there might be applications that your agent is authorized to make decisions on, but the first night it's on your agenda and
Yeah.
received, you can't do that.
And I guess I should clarify, I keep saying that someone is going to intervene because every time someone intervenes, they ask for a public hearing. I look at it that someone's going to have an environmental intervention asking for a public hearing. So I'm wording it wrong, meaning, you know what I'm saying, within that.
For further discussion afterwards.
Yeah.
But, you know, intervener doesn't mean public hearing. You cannot hold a public hearing. The statute's very clear. It says you shall not hold a public hearing unless one of three things is met. So you could potentially, if that application comes in at the last minute, gets that data receipt at the meeting, but you haven't had any time to look it over, at least it's announced at the meeting. So it's in the minutes. So if people are listening in, they kind of get that flag, they hear that. And then at the subsequent meeting, then you can say, okay, staff's had a chance to kind of initially look at this. It looks significant. We should schedule a public hearing. Again, the applicant can grant an extension. It's their burden to prove what to you why they deserve the permit. If they're going to rush things, maybe they haven't proved, you know, established their burden. They haven't proved it. I guess, you know, and for the little sheds and the decks and the pools, you know, the application comes in, it gets the date of the receipt. And I understand that it would be really convenient to just be able to vote on that application the same night. It's just a small thing, right? But the
Yeah.
statute says you have to wait 14 days. So you can't vote on it. You could discuss it, you know,
The
but you can't
statute
vote on
does
it until the
not
next
say
meeting.
that you have to wait 14 days. It says that the decision is not final. I mean, if there's no public hearing, that the decision is not final until after the 14 or 15 days. I mean, that was, I'm not a lawyer, but reading it, I really looked for that wording. So again, I just thought this was a great opportunity to ask you what you thought. In other words, that you make a decision that night and then it's not, you know, the stamp isn't put on the piece of paper until
so
15 days later if nobody has spoken up or petitioned.
So maybe there's additional training that's needed on biases and ex parte communication and things like that. Because if you go ahead and vote on an application before that 14-day window that the public has to request a public hearing, and again, I'm not the lawyer here, but you've kind of predisposed yourself, you've predetermined things, and it may be considered a bias. You need to keep yourself open. You can't vote on anything and go, oh, well, we'll rubber stamp it if we don't get a petition. You kind of have to have an open mind. You can't, you know, that petition might come in. You don't want to judge, you know, if you are in court for a criminal issue to already come to a decision without hearing, you know, your side of the story. So the statute is clear. It gives the public that fundamental fairness that Attorney Willis talked about. It's fundamentally fair to the public to give them their due opportunity to submit a petition. And if you've already made a decision on that application before they've had a chance to talk to you and present evidence, that's not fundamentally fair. I'm not the attorney, but maybe I can play one. I don't know.
Well, no, I mean, that's right, Darcy. No, I appreciate you speaking up and saying those things. It is quite often a conundrum for agencies. But that's just the way it is. There's really no way around it. You end up in a sticky wicket. I've seen instances where things have gotten approved the day of receipt. And someone files a petition 2 days later and then says, well, nobody on the commission here can consider this because you all voted the last time. So, you know, I mean, that's really why you have to do this. If the legislature wanted to change it, they could change the statute. But I mean, that's the scoop. So it's unfortunate sometimes with minor applications, but it is what it is.
A better way to get that notification out in the 14 days, you know, and that's.
I hear you. That's not in the statute.
I know.
That's a practical issue. So if you want to take it upon yourself to start putting notices on your website, that's fine. But that is a practical problem. I could tell you, usually if there's a controversial application coming down the pike, you know, people, you know, they're calling the agency the day before every meeting, say, did you get something? You know, I mean, that's what I've seen. It may not be the way we'd want to do it in an ideal world, but
So it's not broken, keep doing what we're doing and don't fix it. It's kind of,
well,
where-
no, I'm not saying that. If you want to start putting
I'm not
notices,
saying it's, I mean, it's working. There's no good way to fix it and get that 14 days.
the
No.
only way you can do it is you publish a notice on your website of some fashion as soon as you get one. But I mean, even that, you know, it's not going to be the same day. You know, I mean, I don't know how quick you get notices up, but maybe you can get them up the same day. But you know, we've received this in our office, but
No,
I mean,
it's,
yeah,
can I just interject? I mean, it's not just
apparently.
notices. I mean, who goes to the New London Day every day? Who goes to the Hartford Current every day?
Yeah,
Uh,
we're not talking about the newspaper anymore.
I agree with you, Mr. Thompson. I agree with, that's a kind of a separate issue. And I hope the legislature fixes that issue. But I'm not going to put any money on it. That's for sure. So,
Oh, I'm with you, man.
All right, well, it's 9:15 and sorry, I got everybody on
Thank
it
you.
with my 14-day public hearing.
those that need it, you got 2 hours of training towards your 4 hours. So not all of you need it. The wetlands members don't need it. But all the other agencies, if you attended, do. So
Well,
Thank you very much.
yeah,
Yeah.
this
do
is Colin
wanna-
Heffernan. I'm the chairman of the Wetlands Committee. I would like to thank you guys very much for coming out tonight and putting together a really excellent, really informative discussion. I think that you gave us both a lot to think about and hopefully cleared up a lot of areas where there might have been some soft spots, some misunderstandings or some gray areas. And thank you guys so much. It really was an excellent presentation.
thank you.
You're welcome. I wanted a parting thought that Attorney Willis shared with me earlier, and I'm not sure if it was clear tonight because we did cover a lot, but bring your regulations to every meeting. That is your book. Bring your regulations right to every meeting. And I also want to put a shameless plug in for the comprehensive training program that DEP offers for municipal and wetland agencies, commission members. It's an online course. It's free. You could take it at your leisure. It covers everything that we covered tonight. So I encourage you to sign up for that course. You can find it on Yukon Clear's training platform or directly through DEEP's website. But parting thoughts about bringing your regulations? And thank you, by the way, for having me.
Thank you, guys. I really appreciate it.
Yeah.
Take care.
Thank you.
Bye-bye.
Very well. Thank you very much.
You take the courses, so.